Maryland has a well-developed habitability framework that combines state law, local codes, and an aggressive enforcement system, particularly in the Baltimore metro area. If you're a landlord in Maryland, understanding how these layers work together is essential to staying compliant. Maryland's landlord-tenant law is found in the Maryland Code, Real Property Title 8. Within that title, Subtitle 2 addresses residential leases, and Section 8-211 is the key provision for habitability. This section establishes the tenant's right to rent escrow when a landlord fails to maintain the property, and it's one of the most heavily used habitability remedies in the state. Under Maryland law, landlords must maintain the premises in a condition that is fit for human habitation. You're required to keep the structure in good repair and weathertight, maintain plumbing and sewage systems in working order, provide adequate hot and cold running water, ensure electrical systems are safe, provide heating capable of maintaining adequate temperatures during cold months, maintain working smoke detectors on every level, keep the property free from rodent and vermin infestations, ensure common areas are safe and sanitary, and comply with all applicable building, housing, and health codes. What makes Maryland particularly notable is the rent escrow remedy under Section 8-11. This is one of the most powerful tenant tools in the country, and it works like this. If a landlord fails to correct a serious habitability defect after receiving notice, the tenant can file a complaint in district court and deposit their rent with the court instead of paying the landlord. The court then holds the funds and can order the landlord to make repairs. If the landlord complies, the funds are released. If not, the court can reduce the rent, apply the escrowed funds toward repairs, or even terminate the lease. The rent escrow process requires certain conditions to be met. There must be a condition that constitutes a substantial or serious threat to the life, health, or safety of the tenant. The tenant must have given the landlord written notice of the defect. The landlord must have had a reasonable time to make the repair, and the tenant must be current on rent at the time of filing. But once those conditions are satisfied, it's a streamlined process that Maryland tenants use frequently. Baltimore City deserves special attention. The city has its own housing code enforced by the Department of Housing and Community Development. Baltimore requires landlords to obtain rental licenses for all residential properties, and those licenses are tied to passing an inspection. The city conducts proactive inspections and has an aggressive code enforcement division that issues citations and fines for violations. Repeat offenders can face escalating penalties, and in severe cases, properties can be placed in receivership, meaning the court appoints a third party to manage the property at the landlord's expense. Montgomery County and Prince George's County, the two largest suburban counties bordering Washington, D.C., also have their own detailed housing codes and licensing requirements. Montgomery County in particular has a robust rental licensing and inspection program that holds landlords to high standards. Maryland's lead paint laws are among the strictest in the nation. The Maryland Lead Risk Reduction in Housing Act requires landlords of pre-1978 properties to register with the Maryland Department of the Environment, perform specific risk reduction treatments, and provide tenants with lead-free or lead-safe certifications. Non-compliance can result in significant fines and liability, and if a child suffers lead poisoning in a non-compliant property, the landlord faces substantial damages. Maryland tenants also have the right to pursue damages in court for breach of the warranty of habitability. They can seek compensation for diminished value of the unit, out-of-pocket expenses, and in some cases, consequential damages like medical bills or the cost of temporary housing. The state's anti-retaliation protections are found in Section 8-208.1 of the Real Property Code. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant exercising their legal rights, including filing a rent escrow action, reporting code violations, or joining a tenants organization. For the full guide to Maryland's habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.